Shrangika Jaju. SHRANGIKA. Shrangika Jaju.
Okay.
Okay, sir.
Hello, Shrangika.
Morning, sir.
Can you hear us?
Yes, sir.
Please introduce yourself.
So my name is Shrangika Jaju. I belong to Kasganj, Uttar Pradesh. I have completed my school education from Kasganj, and thereafter, with the aim of pursuing my career in judicial services, I joined Lloyd Law College, Greater Noida. I have completed BLLB from there, and after that, I started my self preparation for judicial services, and Rajasthan is my first attempt.
Okay. What is the meaning of this word Lloyd?
Sorry, sir, I'm unaware about it.
Okay. Recently, you are aware the political developments in Bihar.
Yes, sir.
Mr. Nitish Kumar was in majority with the help of BJP,
Yes, sir.
and after resigning and taking oath once again, he is again in majority with the help of RJD and Congress party.
Yes, sir.
What was the need of resignation? Why he resigned? He is chief minister, he was chief minister, he had the majority, still he has the majority. What was the reason for resignation?
Sorry, sir, I have only read the headlines. I'm not aware about the details.
All right.
I think she belongs to Rajasthan.
You belong to Rajasthan?
I belong to Kasganj, Uttar Pradesh.
Uttar
Oh,
Pradesh, okay. But you must be reading newspaper. Do you read newspaper?
Yes, sir. I read.
Which newspaper do you read?
I generally prefer online news from BD News channel.
Okay. You don't read hard copy. Okay. Dear, when you switch on or switch off your television with the help of a remote,
Yes, sir.
which kind of rays are transmitted from your remote to your TV set? What is the name of those radiations?
If I'm not wrong, then it is ultraviolet radiations.
Ultraviolet?
Yes.
I correct you. When you press the button goes red. So it is something connected with red, not violet. Ultra red.
Sorry, sir.
Ultra red rays. Okay. Are you aware what is virus? बोलते कंप्यूटर में वायरस आ गया.
Yes, sir.
What is the meaning of word virus? Full form of virus.
Sorry, sir.
All right. Tell us something about constructive res judicata.
Constructive res judicata is incorporated under Explanation 4 of Section 11, and it states that there are two forms of res judicata. One is actual res judicata, and second is constructive res judicata. Actual res judicata is applied where parties have actually alleged and other party has defended that issue. While in constructive res judicata, that issue might and ought to be made a ground of defense and attack by the parties, but has not been made. But by fiction of law, that will be deemed to have been raised between the parties, and res judicata will also apply there.
Don't you think that this plea of constructive res judicata, to me it appears to be a wrong doctrine, because a plea which was not raised by me in earlier suit, now I am debarred from raising it. Don't you think it is unreasonable? Explanation 4.
In my opinion, it is not unreasonable, because the rationale behind is that there should be an end to multiplicity of proceedings, and party who are litigating should raise those issues which a reasonable person should raise in their suit only. So, sir, in my opinion, it is not unreasonable.
Okay. Do you remember the principle of autrefois acquit
Yes.
and autrefois convict?
Yes, sir.
What is that?
Autrefois convict and autrefois acquit are basically works on the maxim of nemo debet vis vixari pro uno et idem causa. Autrefois acquit means once a person has undergone a trial and he has been acquitted by the court, then he should not be tried again for the same offence. And similarly, autrefois convict means once a person is tried for an offense and he has been convicted, then he should not be tried again for the same offense.
Will you relate it to some constitutional provision also?
Yes, sir. So Article 20 Clause 2.
2 or 3?
So it is 20 Clause 2.
2 is double jeopardy.
Yes, sir.
Okay. And what is 20 clause 3?
So 20 Clause 3 states that no one accused of an offense shall be compelled to bear witness against himself, talking against self-incrimination.
So, Jaju, do you think that this recent Criminal Law Identification Act of 2022, which obliges the police to take biometrics of the accused persons and innocent persons also and convicted persons also, this act, do you think, is violative of right against self-incrimination?
In my opinion, it is not as such violative of right against self-incrimination, because we have guidelines by Honorable Supreme Court in the case of Shalvi versus State of Karnataka. The Honorable Supreme Court stated that an accused can be compelled to give material evidences, but he cannot be compelled to give personal evidences, personal evidences which are in his personal knowledge. So, sir, all these samples like blood samples, swab samples, which are being allowed in criminal identification bill, are a part of material evidences. So, sir, in my opinion, it is constitutional. It appears to be constitutionally valid.
Do you remember the case of ex-Chief Minister of Uttar Pradesh, Mr. Narayan Dutt Tiwari? There was a dispute of paternity with Mr. Shekhar. What was the issue involved?
So far as I am able to remember, this is R.D. Shetty versus Andy Tiwari case, where the question was, can a person be compelled to give his DNA testing for the purpose of paternity test? So basically it was related to Section 112 of Indian Evidence Act, where the Honorable Supreme Court held that a person can be compelled to give DNA testing, and he was allowed to undergo DNA. He was directed to go undergo DNA testing.
All right. Can you tell me who is the Speaker of Lok Sabha nowadays?
Mr. Om Birla ji.
And please name the Chairperson of Rajya Sabha also.
Honorable Vice President Venkaiah Naidu ji.
Who is the present incumbent of Chairman of Rajya Sabha?
Sir, Jagdeep Singh Dhankar ji.
Okay. Right. Okay, can you tell me the last constitutional amendment done in our constitution?
It was 105th constitutional amendment.
What was the topic?
So it was related to Article 342A, 342, where it is allowed that not only the president but also states and union territories may declare other backward classes for their own purposes.
Okay. You know how many MLAs are there in UP Legislative Assembly? The maximum number of MLAs?
So far as I am able to remember, it is 403.
403. Okay. And which one is the summer capital of Uttarakhand?
Garrison, if I am not wrong.
Okay. Please tell us the role of Section 313 CRPC during a trial.
So Section 313 of CRPC basically talks about the recording of statement of the accused. It states that the courts can at any stage ask questions from the accused so that accused can personally explain the circumstances of the case. It is at the discretion of the court. However, it becomes mandatory after taking evidences from prosecution side to examine the accused.
Is there any parallel provision in CPC which you can equate with 313 of CRPC? Parallel provision in CPC. What is Order 10 Rule 1 CPC?
Yes, so Order 10 Rule 1 states about that court will ask the parties as to whether they admit or deny the facts which has been asserted by the other party but has not been directly admitted or denied in their pleadings.
Okay. Last question from my side. What is an exhibited document in a court of law?
An exhibited document is a document which the court admit for the purpose of the evidences.
How a document is exhibited? Suppose you have filed agreement to sell in a case of specific performance. How do you exhibit that agreement for selling? Agreement to sell.
Sorry, sir, I'm unaware about it.
Okay, over to
Okay.
Dr. Verma, please.
Okay. What is your strength?
So I'm very hardworking student and I'm very determined to whatever I decide. I'm a quick learner.
Good. What are the differences between fraud and misrepresentation?
So Section 17 talks about of Indian Contract Act talks about fraud, whereas Section 18 talks about misrepresentation. In layman's language, we can understand it as the intentional misrepresentation is fraud. For instance, there are many instances given under Section 18 where it appears that the other party has intended to induce the opposite party to enter into a contract by active concealment of fact, fraudulent representation, a promise made without an intention to perform it, or any other acts which are declared as fraudulent. Whereas wherein misrepresentation, the party was itself innocent, and as he relied on the facts warranted by other party. So basically the nullified intention, on the basis of that we can differentiate both.
What are the differences with digital signature and electronic signature? Digital signature and
Sorry, sir, I'm unaware about it.
okay. What provisions applied to a magistrate trial?
It from section 238 to section 250, which talks about the trial before magistrate on the basis warrant trial before magistrate. There is section 251 to 259 talks about the summon trial, and 251 to 261 to 65 talks about the summary trial.
What is writ?
So it is basically an order from the Honorable Supreme Court and High Court, whereby the courts directed the other party to perform certain acts or to restrain from doing certain acts. It may be in the form of habeas corpus, mandamus, quo warranto, certiorari, and prohibition.
What is PIL?
PIL is basically a litigation instituted by a public-spirited person on behalf of those persons who, due to some economic disability or other backwardness, cannot appear before the court.
What is the rule of law?
So, as per Davy Desai, rule of law means equality before law, non-arbitrariness, and authority of court.
What do you mean by POCSO?
Sorry, sir, I'm unable to hear your question.
POCSO.
The POCSO Act is the Prevention of Children from Sexual Offences Act 2012. It is basically a neutral, gender-neutral provision which lays down sexual offences against children that are being committed.
Have you heard of the Nirbhaya case?
Yes, sir.
Some highlights.
So it was famously called as Delhi gang rape case. It was committed in 2012, where a girl was gang raped inside a bus by 4 people in the night in the mid capital of our capital. And thereafter, after a hue and cry, there was an amendment in criminal law as well, 2013 amendment, which increased the punishment for sexual offences, changes the definition of rape, and incorporate many other provisions.
What is the scope of 22A CPC application?
So 22A CPC basically talks about those applications where a case has been instituted against the defendant, and defendant does not reside in that jurisdiction, then he files an application before the court, appropriate court, to transfer the petition to another court.
How can a foreign judgment be enforced in India?
Section 44A of CPC talks about the enforcement of a foreign judgment. It lays down certain essentials. For instance, the judgment should be passed by the Superior Court of Reciprocating Territory. The certified copy should be filed here in the district court of our territory. The decree should be a money decree. And then after complying with the requirements, it is executed as if it has been passed by the district court of a country.
What reasons can be used to grant or deny bail?
There may be many reasons to grant bail as well as to deny the bail. While granting bail, the purpose should be that to ensure the presence of the accused before the court as well as to ensure the liberty of the accused. And bail can be denied on several grounds. For instance, there is possibility that accused may flee from India, or accused may commit another offense. Accused may threaten the victims. He may tamper with the evidences. So there may be many grounds.
What does the term lack of jurisdiction mean?
Sorry, sir, I'm not.
Lack of jurisdiction mean?
Jurisdiction means the authority of a court to decide a case, and basically it means I speak by authority of law.
Yeah, can a plea of limitation be taken at the final stage of trial?
So in my opinion, it can be taken at the final stage of the trial as well, provided that it is taken within the time limit.
What is that time limit?
So it is provided in the schedule.
Schedule of?
Limitation Act. Sorry, sir. I got confused, sir. In my opinion, limitation plea can be taken at any stage of the trial, even in appellant court, because it affects the maintainability of the suit.
What is the importance of Section 125 with regard to a female?
Section 125 of CRPC lays down the provision for maintenance to wives, children, and parents. And sir, it is a gender-neutral provision for females for all. So, sir, it is a remedy in addition to the remedy which has been granted to female in their personal laws.
And how much
can a male husband claim compensation from female wife?
In Section 125, he cannot claim it.
And how much is the outer limit of compensation, maintenance which can be granted under Section 125? Outer limit.
So previously there was an outer limit, but now it has been removed from the provision. So sir, today there is no outer limit.
And what was the first leading case in which interim maintenance was granted to wife during pendency of main application? Interim maintenance. First leading case.
Sorry, sir, I am unaware about it.
It is from UP. Case is from UP. Savitri versus Govind Singh Rawat was the first case from UP in which Supreme Court granted interim maintenance during the pendency of main application under Section 125. Sir.
What is the importance of local commissioners in civil trial?
The commission is basically issued to try to take evidences of the witnesses or the parties when the witness cannot be called in court.
What is ad interim injunction and when it is granted?
Ad interim injunction is basically injunction which is granted during the trial of the court, during the pendency of the suit. And sir, this is all I know about ad interim injunction. It can be in form of temporary injunction and in some cases even mandatory injunction.
If the plaintiff prayed the same relief in ad interim injunction and same relief in the main suit, main plaint, can that relief be granted during as ad interim injunction?
In my opinion, it can be granted provided that the remedy which is seeking can be granted at the interim stage. For instance, he has filed a petition for maintenance, then he cannot claim it at interim stage.
Can an accused be a witness in his own case?
Yes, so he can be a witness in his own case.
Under which provision of law?
Under section 315 of CRPC, he can be a witness, and under CPC also order 18 rule 3A says that if plaintiff want to
Please listen. I use word accused.
sorry sir, sorry. He can be a witness under section 315 of CRPC.
What are the requirements of law to be a witness of an accused as a, to become a witness? What are the requirements?
For accused, yes sir. So section 315 says that a person accused can be a witness only if he consents in the writing for the same, and so he can be if he at a later stage, if he refuses or if he is not able to give the testimony or something, that it will not be a subject matter of comment for the parties.
What is the importance of 14th of August? Today is 14th August. What is the importance of this day?
So on this day, Pakistan got independence.
What do you understand by bicameral legislation and unicameral legislation?
Unicameral legislation means there is only one house, that is lower house, whereas in bicameral legislation there are two houses, lower house and the upper house. For instance, in India, in certain states we have unicameral legislation, whereas in certain states we have bicameral legislation.
What do you understand by the term rebuttal? And what is the importance of this term?
So sorry sir, I'm not sure about it.
What is dying declaration?
So dying declaration means declaration made by a person as to any circumstances related to his death, and it is provided under section 32 clause 1 of Indian Evidence Act.
Can an accused be convicted on the basis of dying declaration?
Yes sir, it can be the basis of conviction.
Okay, Shrangika, Dr. Naval,
Yeah.
we have another 2-3 minutes at our disposal.
Yeah.
Shrangika, I am giving you one illustration. You are posted as Judicial Magistrate Class 1. Okay. What are your powers on the criminal side? How much punishment can you grant as Judicial Magistrate Class 1?
So I will be a court of first instance, so the case will first come to me, and I will try that case if that comes within my limit, within my jurisdiction. Otherwise, I will commit that case, and the outer limit of punishment is provided under section 229, that is up to 10,000 of fine and 3 years of imprisonment.
3-year imprisonment and 10,000 rupees fine are your maximum powers.
Yes.
All right.
Yes.
Now suppose you are trying a case of forgery.
Yes, sir.
And you found the accused guilty and awarded 1 year imprisonment and 10,000 rupees as punishment to the accused. 1 year imprisonment and 10,000 rupees fine. The appellate court, district and sessions judge increased this penalty to 4 times, 4 years imprisonment and 40,000 rupees fine. Do you find any wrong in the judgment of appellate court? Any fault?
Yes, sir. So in my opinion, it is a wrong punishment, because as the punishment cannot exceed the limit of the trial court. So it should can maximum be 1 year and 10,000 amount.
No, 1 year you had awarded as Judicial Magistrate Class 1.
Yes.
Appellate court has increased it to 4 times. 4 years imprisonment, it is well within their powers. Fine 40,000 is also well within powers of a district judge. So what is the illegality?
So this is an illegal order. If we see section 386 of CRPC, then it states that it states the power of the appellant court, and it categorically states that the appellant court cannot award the punishment more than the punishment awarded by the trial court. So
Awarded by the trial court, or the maximum punishment which the trial court is empowered to impose.
maximum punishment.
Okay. Is there any parallel provision in CPC also like this?
Sorry, sir, I'm unable to recall at this moment.
All right. I think Dr. Verma, time is over. Dr.
Yes,
Naval, with your kind permission.
Okay, thank you very much.
Yes, sir.
Thank you, Shrangika.
Thank you,
Thank you
sir.
very much, and all the best to you.
All the best.
All the best.
Wish all the best.
Okay, Shrangika, and we will. You can rejoin at approximately near about 12 for your complete review. But more improvement is required to be done. Okay, beta?